Welcome back to another episode of Podcast Bites powered by India Law LLP. I'm your host Neeraj Golani. Today's episode touches something fundamental, the duty of the state to be truthful before the highest apex authority of the land. We are examining the special leave petition CRP number 14087 of 2025, Anwar Hussain versus State of Madhya Pradesh, and two Supreme Court's order dated 4th November and 25th November 2025. These orders tell the story of every citizen, advocate and police officer in India should hear. Anwar Hussain filed a special leave petition before the Honorable Supreme Court challenging a bail refusal order dated 12th March of 2025 passed by the Honorable High Court of Madhya Pradesh at Indore. As in the standard practice, the court called upon the state to file an affidavit detailing the petitioner's criminal history. The state of Madhya Pradesh filed an affidavit claiming Hussain had 8 prior criminal cases, including one under Section 376 of Indian Penal Code, the provisions for rape. That is an extremely serious allegation, but the petitioner counsel categorically disputed that, stating that in favor of those 8 cases, the rape case, Hussain was not even an accused. The court directed the state to file an clarificatory second affidavit on November 4, 2025, before a bench of Honorable Justice Amanullah and Justice Sandeep Mehta. The state's second affidavit came in and it admitted the error. The explanation: the petitioner's name and his father's name were similar, and computer-generated records had mixed up. The bench rejected this outright, calling it as a lame excuse. The court noted that patent facilities had been stated as a matter where the life and liberty of the citizens were at stake. There are few more words. Under Article 21 of the Constitution of India protects the right of personal liberty, and when a false affidavit prolongs unjust detention, it is a constitutional failure. The court found the case fit for bail and directed Hussain release subject to condition to be set by the trial court. It then issued a show cause notice to two officers, Mr. Dinesh Agarwal, Additional Deputy Commissioner of Police, and Mr. Indermani Patel, the Station House Officer of Indore, directing them to personally appear before this court on November 2025 with written response explaining their conduct. When the matter returned on November 2025, now before Justice Amanullah and Justice K. Vinod Chandran, an intervener had entered a picture with IA number 30135 of 2025, sought intervention and replaced additional material before the court. The court found the material important and allowed the intervention, impleading the applicant as respondent number 2. The court examined a affidavit filed by additional DCP and SHO and found the issue went beyond the clerical data error. The intervention application raised serious questions about police conduct under color of official authority and its directed impact on public confidence in law enforcement. In sweeping direction, the court impleaded both officers, the additional DCP and SHO, the respondent number 3 and respondent number 4. When the additional DCP submitted he had only just learned the full facts and would be forwarded them to the Commissioner of Police Indore. The court went further, directing the Commissioner of Police Indore to implead as respondent number 5 by designation. Our newly added respondents were directed to file a personal affidavits. The matter was listed before this court December 9, 2025. Three key takeaways from this case are: fake affidavits are constitutional failures when a state places incorrect information before the highest court of the country in a personal liberty. It is not a procedural lapse, it is a violation of Article 21. Court have consistently held that deprivation of liberty only occurs procedure is unlawful and honest. And point number 2 is personal accountability of the officer. The court decision to implead police officer personally as respondents sends a unanimous message: accountability belongs to the individual, not just institutions. Officer cannot hide behind the rank of department when false information reaches the highest court. Point number 3 is rigorous before swearing in an affidavit and computer error excuse does not hold before the Supreme Court of India. An affidavit is a sworn document before the government officer signs and files it before a constitutional court. Verification must be personal, rigorous and thorough. The case of Anwar Hussain is a reminder that the Supreme Court remains the ultimate sentinel of the individual liberty in the country. When the system fails a citizen, the court corrects it, and here I am did exactly that. I am Neeraj Golani. Thank you for listening the podcast Bites by India Law LLP. Until next time, your rights are never stop asking questions. Thank you.